It's Kevin Glenn here with Investment Housing Specialist and IHS Property Management. Hey, we want to take a minute today. We're going to reach out to everybody and let you guys know what's going on as far as the new laws that are going to be going into effect here on June 11th. We've all been so inundated with everything happening with eviction moratoriums and COVID-19 and that whole situation that this has kind of been overshadowed. So we want to take a minute to show this stuff to you guys. And again, we want to remind you that we don't offer tax, legal, or accounting advice. We're not accountants, nor are we lawyers, and this is purely informational. So let's dive in and see what we got going on. So, all right, let's take a look at what's been going on this year. You may or may not know that there were actually a total of 16 bills that were on the table, and out of those 16, only 4 of them actually passed. And there's some pretty big bills that did not pass and were defeated. So let's take a look at those real quick. The Just Cause bill, rent control, and the ban on the use of criminal records when you're screening. Those were big wins for landlords that those were actually defeated. Again, I want to remind everybody that the laws we're talking about today, all of these laws will be going into effect on June 11th of this year. The first law we're going to talk about is, this one was kind of hidden a little bit, but it says a housing provider cannot require a social security number on a rental application or provide different terms and conditions to a prospective resident that does not maintain United States citizenship. Please be aware that sometimes people come to us and they have work visas, they have TIN numbers, which is tax identification numbers, which are not social security numbers. So you're not able to deny somebody because they don't have a social security number. It's pretty much what you need to understand about that law. This law is talking about now then we have to provide a 5-day grace period before we can charge the late fees, okay? So if your rent is due on the 1st, you have to wait 5 days before you charge the late fee. So rent's due on the 1st, they have all the way up through the 6th to pay rent, and then on the 7th day, you can charge the late fee. Now there's a couple ways. Some of us charge just flat fees of a late fee. For example, we charge $75 late fee. That's what it is. Some people charge X amount of dollars per day that the rent is late. So if you're charging per day, you can go back and retroactive that late fee. For example, if rent was due on the 1st and they're late on the 2nd, you can start charging from the 2nd. So on the 7th day, you can go back and charge a late fee starting from the 2nd all the way up through the 7th. All right. You may also go ahead and issue pay rent or vacate notices on the day after someone is late, and you do want to do that. And in a little while, we'll talk about why you want to do that. This one, a resident may request in writing to change the rent due date up to 5 days after the rent due date in the rental agreement. Here's a big if. If their monthly source of income is government assistance that isn't received until after the due date in the rental agreement, okay? So if someone receives government assistance, that could be Section 8, that could be SSI, it could be VOSH, they need to submit to you in writing that they receive government assistance, that they are receiving it after the due date. They need to provide proof that they're receiving it after the due date. And then you will have to change the due date of the rent. You also need to understand when you change that due date of the rent, the 5-day grace period starts from the new rent due date. So if rent was due on the 1st and you ended up changing it to the 3rd because you needed to, the 5-day grace period starts from the 3rd, not from the 1st, but from the 3rd. So 5 days out from the 3rd. That's important to know. Residents may now request to pay damage deposits or security deposits, however you look at it, fees, and last month's rent, if you collect that, in installments, okay? So here's the thing. If a rental agreement is 3 months or less, basically month to month, a resident can make 2 installments. And the thing is, a resident can make the 2 installments of equal installments with the first payment being due at move-in. The second payment is due the very next month, along with rent on the rent due date. If the rental agreement is 3 months or longer, say 3 months, 6 months, 9 months, 12 months, anything there in between or greater, like ours are 12 months, a resident can make 3 consecutive equal installments with the first payment due at move-in. So they can make 3 installments. The first one's due at move-in, the second one's due the second month along with rent on the due date, and the third one is due the third month along with rent on the due date of rent. it would be very prudent, and you need to do this. You need to put it in writing, have a separate addendum with the amounts and whether they're 3 months or less. If it's two equal installments, or if it's 3 months or greater, it's going to be the three equal installments, the amounts, when they're due. You sign it and have all the residents sign it. You also need to understand that you may not charge any fees or interest if they request a payment plan. You can go, hey, resident, great, yeah, we'll do the payment plan, but I'm going to charge you a fee for it, or I'm going to charge you interest. You may not do that. Holding fees. What are holding fees? If you're not aware of what they are, for example, holding fees, we sign an intent to lease form with a resident who's applied for a property, been through the process, been vetted, they've accepted the property, but they can't move in till a later date. Say they've been vetted, everything's done on the 5th, but they can't move in until the 10th, and we're going to hold that property for them. We haven't signed the intent to lease agreement. Right now, our holding fee is equal to the damage deposit. And so when they sign their lease agreement, that then rolls over and becomes a refundable damage deposit. If for some reason they didn't sign the lease, then we would retain that as a holding fee. Okay. Now then, holding fees are limited to 25% of full month's rents, which means we're going to have to change what we charge for holding fees. Now then, if the rent, let's say it's full month's rent's $1,000, we're only going to be able to charge $250 for a holding fee. So just be aware, whatever your full month's rent is, you can only charge 25% of that for the holding fee. And then you can decide whether that's going to be applied to the damage deposit or that'll be applied to first month's rent. Just make sure you disclose it in the paperwork. Residential tenant protections. A lot of this has to do with the pay rent or vacate notices and what's happening there. Big thing you need to know here is if you are not currently using the pay rent or vacate notices on the Attorney General site, you need to. And after June 11th, you need to switch over to the new version that's coming out. It's going to add some things that I'm showing right here, the Northwest Justice Project, the website. Those things are being added. There's a few other things being added to it, but a couple things you need to know is that it's removing the option to pay with cash. Like right now on the one we have currently, you have to receive a cash as a payment. They have now taken that away to where you do not have to accept cash as a payment. However, if you still do, just make sure you receipt it. This was a big one. This was one of the cornerstones when they first negotiated this bill. Was there was a 3-strike language. If you're not familiar, remember I said you want to serve those pay rent or vacate notices. If a resident receives 3 or more pay rent or vacate notices inside of a 12-month period, they cannot ask for a payment plan, and a judge cannot use judicial discretion and institute a payment plan. It's done. They can't do that. Okay. Couple things you need to know is you need to make sure you are serving those pay rent or vacate notices correctly. And if you're not sure how, go research on how to serve a legal notice correctly, because my understanding is there have been a few judges that were looking to make sure they were served correctly. And if they weren't, they were throwing them out. And that landlord or property manager was having to start all over again at ground zero. And so you got to start like it's the first month again and start it all over. So just make sure you're serving those correctly. Also, it restores the attorney fee language that was in the bill originally. You can go take a look at it. There's too much to get into right now. Besides, if you get to that point, you want to seek legal counsel anyways. Another thing is people have made this mistake. This prohibits a landlord from threatening eviction for non-payment of fees. Really what we're talking about are like late fees. You can only put on your pay rent or vacate notice any reoccurring charge, such as rent. So if your rent's $1,000 and your late fee is $75, you can't put resident owes $1,075. You can only put on there that the resident owes $1,000. If you add that late fee on there, or you threaten eviction and you have that late fee on that pay rent or vacate notice, it'll get thrown out. So just make sure that you can, for example, if you've got pet rent can be put on there, or any other reoccurring charge. Maybe there's a utility charge and that can be included in there, but you cannot include late fees. This one that's talking about, we are now required as landlords to accept emergency rental assistance funds. So this one's a little interesting. The tenant shall provide a copy of the pledge of emergency rental assistance provided from the appropriate governmental or nonprofit entity. So if a government source or a nonprofit entity pledges, then you get a pledge that came from that department, whatever it was to you and the resident gives it to you, you have to accept it. There's a couple different scenarios that this works in. If the resident comes to you prior to the expiration of the 14-day pay, rent, or vacate notice, language says the landlord shall accept any pledge of emergency rental assistance funds provided to the tenant from a governmental or nonprofit entity before the expiration of any pay or vacate notice for non-payment of rent for the full amount of the rent owing under the rental agreement. So they come to you with that pledge for the full amount of rent prior to the 14-day pay, rent, or vacate notice expiring. You have to accept it. You also have to suspend any legal action for 7 days after they've brought that to you. Let's say resident doesn't come to you prior to the 14-day and the 14-day pay, rent, or vacate notice, it is expired and we're moving into the next month. The law says this: the landlord shall accept any written pledge of emergency rental assistance funds provided to the tenant from a governmental or nonprofit entity after the expiration of the pay, rent, or vacate notice if the pledge will contribute to the total payment of both the amount of rent due, including any current rent that is due, and any other amounts if required under this subsection. So if there were some legal things that were paid for, you may be able to get those as well. You need to read the law closely about that. And I would highly suggest that you seek legal counsel if you find yourself in this situation. So I hope this helps everyone. Again, my contact information is on the slides. Feel free to contact me, and everybody have a great day.